Call this meeting to order. Welcome to meeting number 87 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefits of witnesses and members. Please wait until I recognize you by name before speaking. Feedback events can occur. These can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece worn too close to a microphone. We therefore ask all participants to exercise a high degree of caution when handling the earpieces, especially when your microphone or your neighbor's microphone is turned on. A reminder that all comments should be addressed through the chair. Pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, October 23rd, 23, the committee resumes its study of rights of victims, reclassification and transfer of federal offenders. I would like now to welcome our witness for today by video conference, Mr. Tim Danson, lawyer and legal counsel for French and Mahaffey families. Welcome, Mr. Danson. It's great to see you here.
Thank you very much for having me.
So we will go right in.
Mr. Chair?
First question.
Monsieur le Président.
Mr. Chair? If you'll allow me.
Mr. Danson, please bear with me.
I know. D'abord, merci.
First off, thank you. I'm pleased to be here to replace Madame Michaud, who is in her riding. I just wanted to ask whether the sound tests have been done for the witnesses remotely, and have these tests been successful?
Yes.
Merci.
Thank you. Mr. Danson, I know I pre-authorized basically a 10-minute opening remarks for you today. So if you want to start now, we'd be appreciated. Thank you.
Thank you very much. Thank you for inviting me to appear before this committee today on behalf of the families of Kristen French and Leslie Mahaffey, who I've had the honor and privilege to represent for the past 30 years. Appearing in public to speak to these issues is simply too painful and emotional for the families, and they have asked me to speak on their behalf. My representation of the families over the past 30 years informs the opinions that I'm going to share with you today. This includes guiding them through the criminal justice system, Bernardo's trial, battling the media and certain members of the public who unsuccessfully tried to gain access to the Bernardo Homolka videotapes. This was an enormous undertaking. This was an enormous undertaking, which itself included the need for me to painstakingly review the videotapes and prepare a chart describing every frame of the videotapes and the corresponding words. This fact alone is perhaps the most significant fact that will inform some of the opinions that I give today, and perhaps answering some of your questions. Because that was a very difficult process in reviewing the videotapes. This was necessary for the particular argument that we advanced at the time of the videotape motion. We were also involved in the resolution of the plea resolution involving Karla Homolka. Our efforts to have Karla Homolka's plea resolution set aside because we believe that she breached it. Dealing with a little-known potential plea bargain for Paul Bernardo to second-degree murder, which we stopped, even though it would have avoided the trial altogether and avoided the excruciating videotape issue. We were involved in the successful gating application to keep Karla Homolka in jail for her entire 12-year sentence. We went to Joliet, Quebec at the conclusion of her sentence to impose post-sentence conditions on Karla Homolka pursuant to Section 810.1 and 810.2 of the Criminal Code. Where during that particular process, Karla Homolka chose to stare me down in court, and where I saw for myself the evilness in her eyes 12 years later, which was identical to what I saw in the videotapes. We were involved in the appeal processes. We're involved in the bone-chilling discussions we had after Bernardo was convicted and had exhausted all of his appeal routes that led us to obtain an order to destroy the videotapes, the crime scene pictures, the autopsy photographs, the steel circular saw that he used to dismember Leslie Mahaffey. We had everything destroyed. And now we're involved in Mr. Bernardo's parole hearings. We're currently before the Supreme Court of Canada with the assistance of the Toronto Police Association on a leave application regarding the family's Access to Information Act request for the records of Paul Bernardo and other offenders who murdered police officers, which they rely upon to persuade the parole board to grant them parole, and what Corrections Canada and the parole board need to discharge their legislative public safety mandate. As I have said just a moment ago, all of this will inform what I have to share with you this morning. But I know this, on these issues, the public interest and the victim's interests are fully aligned. But for the grace of God, go I. With the exception of a public loony campaign 30 years ago, which I had nothing to do with, all of my work for the families has been and continues to be pro bono. Helping these families free of charge is a far greater reward than all the money in the world. And the families wanted me to share a number of points with you. First, all they seek is justice. They don't seek revenge. They don't seek retribution. They accept that Paul Bernardo is entitled to full constitutional protections, the right to be presumed innocent, the right to a fair trial. He got both. They accept that Mr. Bernardo is entitled to humane treatment in jail and that he has a right to seek release on parole. The question, though, that must be answered is what is justice for a convicted, sadistic, sexual psychopath who committed the most unspeakable crimes known to humankind and who was sentenced to life in prison and additionally designated a dangerous offender? An offender who, after 30 years in prison, right up to his transfer, as found by two different panels of the parole board, had no remorse, no empathy, no insight, and was not treatable. I wish all of you could see, and this is part of our application before the Supreme Court of Canada, even listen to the audio recording of Paul Bernardo's testimony. It would go a long way in people understanding who this person is. In designating Paul Bernardo a dangerous offender, the learned trial judge, one of the most distinguished and experienced judges in the country, Associate Chief Justice Lesage, as he then was, later became our Chief Justice, recounting the unspeakable sadistic brutality Bernardo inflicted on two innocent, defenseless teenage girls and so many others, said this to Mr. Bernardo, quote, "You require jail, in my view, for the rest of your natural life. You are a sexually sadistic psychopath. The likelihood of you being treated is remote in the extreme. For offenders like Paul Bernardo, the overarching principle must be maximum punishment in a maximum security penitentiary. The Supreme Court of Canada tells us that sentencing is the means by which society communicates its moral values. These types of offenders can still obtain the benefit of programs offered by maximum security federal prison in maximum security federal institutions. They're still entitled, as I say, to the regular parole hearings. But never should such an individual be rewarded with a transfer from maximum security to medium security when at the time of the transfer, the offender still showed no remorse, no empathy, no insight into his crimes, and the medical evidence was that he was beyond treatment. It sends the wrong message. It sanitizes the full brutality of his unspeakable crimes. It's no answer that the perimeter security is the same as a maximum security, or that medium security offers better treatment programs for a person that cannot realistically be treated, or by giving him more freedoms and privileges in medium security because he might be more manageable. Offenders like Paul Bernardo, who commit the most unspeakable crimes known to humankind, must receive the most severe sentence our legal system permits. That means spending the rest of their lives, the rest of their natural lives, in a maximum security institution. When Leslie Mahaffey and Kristen French took their last breath in utter horror at the hands of Paul Bernardo, upon conviction, the only rights he has left is to remain alive because we don't have capital punishment. And I don't believe in capital punishment, but that's one right he has, and to spend the rest of his life humanely in a maximum security federal penitentiary. The second point the families wanted me to bring to your attention is this. They have this question. Upon Mr. Bernardo's transfer, the Prime Minister of Canada, the then minister responsible, and I believe other political leaders properly described the transfer as both shocking and incomprehensible. Not my words, not the family words, the words of the Prime Minister and the Minister. Canadians were instinctively outraged. It offended all ethical and moral standards, and it was wrong. Even if Corrections Canada followed the rules, which I have a lot of issues with, but assuming it complied with all the rules, complied with all the laws, how can something, this is the question the families have, how can something that is shocking and incomprehensible remain the law of this great country? If it's shocking and incomprehensible, then change the laws. This is exactly what leads to public cynicism and disrespect for the administration of justice and the rule of law. I will never forget, after the first day of argument on the videotape issue, a discussion I had with Donna French. The courtroom was packed. There was an army of media lawyers. Everybody's robed up, very official. There was motion records, factums, endless books of authorities piled up on counsel's table. Yet Donna French cut through all of this and said this to me: I don't understand. We have a right to protect the dignity and memory of our daughter. Some things are right and some things are wrong, and this is wrong. And she was right. And this equally applies to Paul Bernardo's transfer. It was wrong. And this takes me to the family's third point. In practice, and I've been doing this for 43 years, in practice, the system treats most offenders the same. And we submit to you that you cannot treat offenders who receive fixed sentences the same way that you treat offenders who receive life sentences, and additionally, in Bernardo's case, an indeterminate sentence because of his dangerous offender designation. There is no cure for psychopathy, worse, for sadistic sexual psychopathy. That is a medical fact. If the public knew that there were tough but just laws for Canada's most dangerous offenders, they would embrace the full panoply of treatment and rehabilitation programs for the overwhelming majority of federal inmates. This kind of one-size-fits-all criteria, mechanically checking the boxes, cannot apply to Canada's most dangerous offenders. There must be a separate law for these people. Only this way will Canadians have confidence in our justice system and embrace treatment programs for the vast majority of offenders. The fourth point they wanted for me to communicate to you is this: the reliance on Section 28 of the Corrections and Conditional Release Act and the requirement that the choice of penitentiary must be the least restrictive for offenders is completely misplaced. This is appropriate for the vast majority of offenders who serve fixed sentences, but it is not appropriate for people serving life sentences for murder and or have indeterminate sentences because they've been declared dangerous offenders. This distorts the sentence itself by substituting punishment for leniency, and this may be better for the parole board rather than administrative decisions. But really, in my experience, this least restrictive principle has been more aptly applied to NCR offenders. The fifth point they want me to communicate to you is this: one of the justifications for the transfer was that Paul Bernardo did not represent a threat to attacking prison guards or other inmates. This cannot be a criteria for offenders like Paul Bernardo. These types of offenders, these types of sex offenders, they're cowards. Paul Bernardo is a coward. He would never attack a prison guard or another inmate. He would only attack innocent, defenseless, vulnerable teenage girls and young women. So this criteria must be eliminated for offenders like Paul Bernardo. The sixth point is...
Mr. Danson,
Yes?
could I stop you there? We're much over our 10-minute allotment that I allowed you, so I don't want to cut short some people's questions, and I'm sure they're going to get to some of the information
Sure.
that you're addressing.
Point of order,
No
if
problem.
I can. If Mr. Danson's getting to his final point, perhaps there's unanimous consent to let him finish.
Thank you, Mr. Danson. The committee would like to see you continue, so let's continue. Thank you.
Okay, I'll do one more point, and I'll leave the last two for hopefully questions. But the last one, because it deals directly with a criticism that we have with respect to justifying the transfer of Mr. Bernardo on the basis of his recent full integration with other offenders on his range is stunningly weak and completely detached from the sheer sadistic brutality of his crimes. That range in maximum security is very limited. Further, I think the committee, everyone knows this, the hallmark of psychopathy, of psychopaths, is that the offender is cunning, deceptive, manipulative, a liar, callous, glib, grandiose, narcissistic, and often intelligent. This was the expert evidence before Associate Chief Justice Lesage at the time of the trial and the dangerous offender application, and this is the evidence before the parole board. So these type of offenders learn how to manipulate the system and the various tests that are being applied to them, and they learn from test to test. So therefore, there just has to be a different criteria to be applied to these individuals. And thank you for the extra time, and I'll happy to take your questions.
Thank you, Mr. Danson. We're going to start with questions with Mr. Shipley, please, for 6 minutes.
Thank you, Chair, and thank you, Mr. Danson, for being here today, and thank you for your patience with trying to get scheduled in with last week and today, and thank you for all the work you've done for the families, especially hearing this morning that's all been pro bono, so good for you. I'm sure some very trying times, as you mentioned. Mr. Danson, you on behalf of the French and Mahaffey families have rejected the findings of the report on Paul Bernardo's transfer. You said, and I'll quote you, "We believe that Paul Bernardo should be in maximum security prison," end of quote, and that even if the transfer was done in accordance with all applicable laws and policies, those laws need to change. Can you expand on why you reject the findings of the report on Bernardo's?
I have to stop you there, Mr. Shipley. We just have to suspend for 1 minute, Mr. Danson. We seem to be having an issue with our communication.
Nope.
Okay, we'll continue. Just to remind everyone to keep their earpieces away from the microphone when speaking. And I'm going to restart Mr. Shipley's time, please. 6 minutes, Mr. Shipley. Thank you, Mr. Danson, for your patience.
Thank you, Mr. Danson, and thank you, and sorry to the interpreters for that loud noise. It was loud out here, too. Not sure what that was. Mr. Danson, in order to save some time, I won't go back through exactly what all I was speaking of. I'll just paraphrase it a little shorter. Can you expand on why you reject the findings of the report on Bernardo's transfer and why you believe Paul Bernardo should be in maximum security prison for the rest of his life?
Well, I think that the criteria that they use, notwithstanding words to the contrary, do not differentiate between these kinds of offenders, someone like Paul Bernardo, which is very fact specific, and the overwhelming majority of offenders. So I think there has to be an entirely different legislative and regulatory criteria for these individuals. And as I said in my opening, we must eliminate for these type of offenders the notion that the penitentiary sentence has to be the least restrictive. That is inconsistent with the sentencing principles, and it's inconsistent with what the trial judge, sentencing judge, had to say about Mr. Bernardo. And then, as I said a moment ago, this criteria that, well, because he's not representing a threat to the prison guards and other inmates, that's a justification for transferring him to medium security, or that he had fully integrated into a particular range that is very small. There just has to be a fundamental shift in establishing a separate criteria for Canada's most dangerous offenders, and don't put them in the mix of a criteria that applies to the overwhelming majority of offenders. And as I said, when you do that, and I mean, this one bit of information that I think I can impart to the committee with my 43 years of experience, if you do that, if the public knows that these type of offenders are being dealt with properly, then there will be an enormous view of the public to embrace all of the rehabilitation programs and assistance for offenders to make them productive when they eventually get out. But you can't apply that to people like Paul Bernardo.
Thank you. Building on that answer, Mr. Danson, in your response to Correctional Service Canada's report, you stated, and I'll quote once again, CSC's heavy reliance on Section 28 of the CCRA and the requirement that the choice of penitentiaries must be the least restrictive for the offender is misplaced, end of quote. Can you describe how the least restrictive principle being applied with a one-size-fits-all criteria is dangerous for public safety and re-victimizing for victims and their families?
Well, it's contrary to the facts. It's contrary to the facts that apply to this particular offender and similarly situated offenders. As I said, the least restrictive test was what really had currency with respect to offenders who were found not criminally responsible. It just doesn't apply to these kinds of offenders. As I say, it's fine if you apply it to the majority of offenders who have fixed sentences, and they're going to get out regardless. But it just has no application, and it's completely disconnected from the punishment principles of sentencing. And if one looks at 718 of the Criminal Code, in a case like Paul Bernardo, the preeminent principle is punishment. And that's completely inconsistent with those sentencing principles. It's got to be changed.
Thank you. You've spoke about the need for different criterion to be applied to offenders who exhibit hallmarks of psychopathy. That's a tough one for me on a Monday morning, psychopathy. Can you expand on how an offender like Bernardo may be able to manipulate the test being applied to him to be granted a lower security classification?
Well, yeah. Again, as I said in my opening, I mean, it's the evidence that was before Associate Chief Justice Lesage at the trial and at the dangerous offender application, and it's the same evidence that was 25 years later and more before the parole board, is that this is the hallmark of psychopathy. They are deceptive, they're cunning, they're manipulative, and to have a criteria that doesn't take that into account and doesn't take into account what they learned from the various programs that are administered to them, and what they learn from parole hearing to parole hearing is simply naive. And so therefore, thank God the majority of offenders in Canada serving federal penitentiary sentences are not psychopaths. But again, this is why you can't have one size fits all. You have to have an entirely different criteria for these particular types of offenders. It's critical.
Thank you. This will probably be my last question, Mr. Danson. You have mentioned many times that the parole process is harmful for the French and Mahaffey families, given that they need to testify and provide victim impact statements every 2 years, even though Paul Bernardo is serving an indeterminate sentence. Can you speak to the reforms you would like to see to ensure that the parole process for dangerous offenders with indeterminate sentences prioritizes victims' rights?
Well, I can tell you every time we get ready for a parole hearing, it is gut-wrenching for the families when we prepare their victim impact statements. And in the case of the French and Mahaffey family, we prepare very comprehensive victim impact statements. I think that, what happens is that as a general rule, parole hearings happen every 2 years. And the reality is for the families is that you finish one parole hearing and that 2 years goes by very fast. And it's very, very difficult to revisit this every 2 years, in my view. And actually, as a matter of law, they're actually entitled to a parole hearing on an annual basis once a year. Then the parole board has 6 months to process that, and as a matter of practice, it just works out to every 2 years. In my view, we'll use Paul Bernardo as an example. He's now had 2 parole hearings. But after the first parole hearing, maybe after the second parole hearing, there has to be a shift, particularly when there's a finding that he has no insight, no remorse.
Thank you, Mr. Danson. Thank you, Mr. Danson, and we'll continue, and hopefully you can pick up on those comments as we go to later rounds. Next up is Ms. O'Connell, please.
Thank you, Mr. Chair. Thank you, Mr. Danson, for being here, or sorry for the technical difficulties last week. But I think it's really important that your clients, the families, their voices are represented through you. So I really appreciate having the opportunity to hear this testimony. You spoke about, first of all, I want to also acknowledge and thank you for speaking about what happened during the trial. As someone from Pickering and right next door to Scarborough, we remember all too well the failure in policing for women. And you bringing it up here is part of the first time that we've actually talked about it. And so I thank you for that, because it's an important piece that has been lost in a lot of this debate. So thank you for raising that as well. It's something that is frustrating for me all these years later still. But in terms of the issue at hand, I just wanted to ask you further. You spoke about changing the laws, and we have a private member's bill before us that would actually change the laws to anyone who's designated a dangerous offender. There's 921 of them that would be in maximum security if passed for the entirety of their sentence. However, that would mean people not criminally responsible. That would mean people who might be able to benefit from programming. That would mean an overrepresentation of Indigenous and Black offenders. There are people with determined or fixed sentences, as you spoke about. So I found your testimony interesting to focus on fixed sentences versus indeterminate. And that may be an area that would be, one, constitutionally something that might not be as heavily challenged, I don't know, but two, would not create the one-size-fits-all on the reverse, where you have those who may one day be released because they are on a fixed sentence, certainly not in the case of Paul Bernardo. And so do you have additional thoughts on the classifications for those without fixed sentences and how that could be a better application of changing the laws?
Well, there has to be a clear distinction between indeterminate sentences from people found not criminally responsible. And of course, there's an entirely different regime and review panel that deals with those individuals. That cannot, and that's important that be maintained. But that can't be confused with the indeterminate sentences that come from a dangerous offender application, where the criteria, as you all know, for a dangerous offender is exceptionally high. And often you see it in a situation like we have here, where Mr. Bernardo has been convicted of 2 counts of first-degree murder and many other offenses, and then in addition been declared a dangerous offender and therefore has an indeterminate sentence. So in that sense, the 2 regimes must be treated completely differently. And quite frankly, if they weren't treated differently, then it would be unconstitutional.
And you spoke in your testimony about, you kind of raised questions about how CSC came to this conclusion, and you kind of questioned that process. Could you perhaps elaborate on some of your concerns in how, I think you said, sorry, I didn't write it down exactly, and I don't want to put words in your mouth, but checking off the boxes or the test that was kind of done. Can you maybe elaborate a little bit more on your concerns around CSC's classification process?
Well, notwithstanding that they think that their criteria can differentiate between Paul Bernardo, people with life sentences, and someone who has a fixed sentences, my experience has been, as a matter of practice, and what I have experienced and witnessed, is that they actually keep them all in the same category, and they do not make a distinction. And that applies to their belief in rehabilitation. I mean, let's be clear. Rehabilitation and working with offenders with fixed sentences who are ultimately going to get out is critical, and there must be the resources that allow Corrections Canada to carry out these important rehabilitation programs. But as I keep saying, that you have to draw a hard line between the overwhelming majority of offenders with these fixed sentences, with the Paul Bernardos of the world. And as I say, one of the key sentencing principles in the criminal code, under 718 of the criminal code, is punishment. And when you commit the most serious of offenses, you should be faced with the most serious of consequences. And in my view, for someone like Paul Bernardo, that's spending the rest of his life in maximum security. It seems that they seem to forget, and maybe I'm at an advantage, or maybe it's a disadvantage for having unfortunately had to do what I had to do with the videotapes themselves. Anyone who actually understands what this man did is so horrific. That when the experts are telling you he's beyond treatment, that doesn't mean you don't give him treatment programs that exist in maximum security penitentiaries, but you don't move him into medium security. And there is, notwithstanding they say they would never move him into minimum security. In my experience, over time, there is a cascading effect, which is of deep concern. And in my view, it is the punishment side sending that message. Fortunately, for a very few number of offenders, that has to take priority.
Thank you.
Hanson, thank you, Ms. O'Connell. We're going to move on to Mr. Fortier, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Actually, it's Mr. Fortin, not Mr. Fortier, if you will, Chair. Mr. Dawson, thank you for being here with us today, for sharing this information and shedding this light on the reality of victims. Of course, in the case of Paul Bernardo, needless to say, we're just completely shocked by this type of crime, and I wanted to share with you, through you actually, to the families, our deepest and most sincere condolences. I can simply not imagine the pain that they've experienced. That said, Mr. Dawson, we're looking at changing the rules at play right now, and I'm hearing what you're saying, and correct me if I'm wrong, but what I gather as perhaps being the most important part of your testimony is that in some cases, like this one, the principle of having a sentence that limits rights to the maximum degree is not the option. Really, a person should be, in this case, in prison for life. And correct me if I'm wrong again, but I'm hearing you say that you believe in rehabilitation, and in the majority of cases, many efforts and resources should be spent on making sure that criminals that are behind bars, inmates can have an opportunity to be rehabilitated, and that when they are finally released, that they no longer be a threat to public safety. That being said, I have the following question. Where should we set the limit, that line between cases where we can rehabilitate people and have this concern about depriving them the least, and then cases like Paul Bernardo, where these people have to remain behind bars? Where is this line drawn? Are you in a position to clarify for us that question? Where exactly should we set that limit?
Thank you very much for that question, and I agree with basically everything that you say, because I believe and the families believe in rehabilitation for offenders. But to your question, where do we draw the line? We draw the line with offenders such as Paul Bernardo. We draw the line with people who murder children, who are sadistic sexual psychopaths. As I said earlier, thank God there are a minority of offenders, but they're the ones that grab the public attention. They are the ones that the public kind of evaluates its confidence in the administration of justice. And that's why I say that we have to draw, it is important to draw the line. And for myself, the direct answer to your question is that we draw the line with sex offenders such as Paul Bernardo. And it may be that because they are a minority of offenders and the ones that the public is most frightened about, is that maybe these decisions should not be administrative. Maybe these should be decisions of the parole board itself, that there maybe be a hearing that the parole board itself decides whether or not this particular offender is appropriate for a transfer to medium security. And it shouldn't be done behind closed doors, but it should be done publicly, transparently, so the public themselves can evaluate whether or not the process is working properly. If Paul Bernardo has kind of earned the right to be transferred from maximum to medium, then let that be at an open public parole hearing. Let people hear the evidence. But can you imagine, as I said in my opening, to reward Paul Bernardo with this type of transfer when two different panels of the parole board says after 30 years he's got no remorse, no empathy, no insight? That can't be justifiable. And so I would recommend that for these types of offenders, these types of decisions should be made by the parole board and not internally and administratively by Corrections Canada that are done in secret.
Merci. Monsieur Danson.
Thank you. I hear you on these sexual offenses, and it's the issue of the transfer. That's another issue I want to address. But am I understanding correctly that to you, Paul Bernardo is an exception among offenders who have committed sexual crimes, sexual offenses? I suspect, and perhaps correct me again if I'm wrong, but all sex offenders do not necessarily deserve the same treatment. You're saying Paul Bernardo is an extreme case, and I have no difficulty in agreeing with you on this. We agree that this is not a common occurrence. Now, on the issue of where to draw the line, to you, are all sex offenders, should they all receive this type of treatment? In other words, they should no longer be eligible to transfers or releases.
No, I draw a distinction even within sexual offenders because, as we know, there is a full continuum from, all sex offenses are horrific, but there is a continuum from less serious to most serious, and so obviously there are a number of sex offenders that you may be amenable to rehabilitation. So again, it is fortunately a minority. I'm talking about sex offenders who are psychopaths and have committed murder or have committed just egregious, sadistic physical harm on children and women. That's where I draw the line. And that's why I say it's actually an easy solution because this is what the public sees. And when the public sees that you treat someone like Paul Bernardo and that the criteria are in practice like everybody else, that's what brings cynicism and disrespect to the administration of justice. So I think we can draw a hard line.
Thank you, Mr. Danson, and
Merci.
thank you, Mr. Forte. We're going to move on to Mr. Julian now.
Words can't describe the profound condolences we all feel to the French and Mahaffey families. And Mr. Danson, I wanted to thank you profoundly for the work that you undertook to destroy the videos, the horrific videos that Bernardo made. I just can't imagine in today's social media environment what that would mean. And so your work has been fundamental in preserving the dignity and memory of those daughters, for those families, and I'm sure gives some small measure of peace in absolutely horrific circumstances. So our profound thanks to you for that work. We are studying now the system of transfer within correctional services, and we had Ms. Kelly from Correctional Services Canada, who came in, testified 2 weeks ago, or a week ago, saying that victim statements, victims or victims' families are taken into consideration, and any time the victims can submit a new victim's impact statement. I wanted to ask you, because that says to me that the onus is on the victims' families to keep track of what correctional services is doing. The onus is on the families to try to keep up to date to ensure that the victims' impact statements and victim statements are there. To what extent do you feel that that is the disrespect to victims' families, that the onus is on them? And when we couple that with the fact that correctional services doesn't provide the information that is so important of possible transfers, what is the impact on families when we have this double jeopardy of the onus being on the victims' families and correctional services not informing them about transfers?
Well, certainly the way they handled this case and the transfers was dreadful. I mean, we didn't find out until the transfer was in motion, actually happening. So we were not given any opportunity to respond, and I take it that was probably very calculated and deliberate, and that's unfortunate. The only time that they really prepare victim impact statements is getting ready for the parole hearings, and that, as I said, is a gut-wrenching process for them. It takes them back to day one. It's very difficult. But it also is why we have this access to information application, which is now currently on a leave application to the Supreme Court of Canada, where Corrections Canada says everything is private and you're not entitled to anything, even though that's not the law. You know, the laws. And let me just back up by saying we need this information to prepare proper victim impact statements and make sure that the evidence is out there to make a determination whether it's a transfer or whether it's a parole application. These are like parole hearings. They're public hearings, and these offenders are asking for a public remedy. They're asked to be relieved from the full consequences of their life sentence and be reintegrated back into the community. This is a public hearing. They're asking for a public remedy. Yet Corrections Canada and the Parole Board throw up, privacy rights of these offenders. Anyone who's attended these parole hearings knows that the most detailed personal information comes out at these hearings. So this notion of not sharing the relevant information for an informed decision in a constitutional democracy where the public has a right to know so they can evaluate whether the government institutions are happening proper, are conducted properly, requires transparency. So and this is very, very difficult for the families. But as I said, this matters now on a leave application before the Supreme Court of Canada, and hopefully leave will be granted and we can get some clarity from our highest court with respect to these issues.
Thank you for that answer. Now we also had testimony from correctional officers, their union, and the Union of Safety and Justice Employees, that often the prison guards, others who may be aware of the kind of behavior that a psychopath like Paul Bernardo would exhibit. As you mentioned, it is easy to manipulate certain tests, particularly when they're predictable. It is less easy to manipulate what is the daily behavior of the inmate. And so do you believe that there needs to be a vast consultation even within the institution to ensure that we don't have psychopaths with psychopathic tendencies trying to manipulate tests? We actually get a better sense of what how that inmate is behaving in prison. And that needs to be criteria that is considered before there's any sort of attempt to transfer that inmate.
Well, I agree with that completely, but it's also why I say with these particular types of offenders that maybe this is something that should be ultimately determined by the parole board and not administratively by Corrections Canada. But for sure, it has to be considered. But there we need transparency. And we don't have transparency at all. I mean, they gave us nothing on our access to information requests. based on, in this case, the privacy rights of Paul Bernardo and the privacy rights of two other offenders who murdered police officers, one who was executed. No, transparency is the quintessential soul of our justice system and our democracy, and we need more transparency.
Are there other things that you believe we need to be considering in terms of the French and Mahaffey families, things that would have been made this process less traumatic for them, would have given them more of a measure of peace? Other things you can recommend to us?
Well, certainly in this particular case, it would have been much easier for them if they had had advance notice and had an opportunity to voice an opinion, even if it's, quietly behind the scenes. But to be told effectively after the fact of the transfer was a kick in the gut for them. It was just horrific. And
with that, Mr. Danson, thank you, Mr. Danson. And we're moving on to Mr. Baldinelli, please, for 5 minutes.
Thank you, Chair, and thank you, Mr. Danson, for being here, and thank you for your steadfast advocacy and support of the French and Mahaffey families throughout all these years. Mr. Danson, you make reference to Justice Lesage in your opening, and who spoke of the likelihood of Bernardo being treated as remote in the extreme. Last week, Commissioner Ann Kelly was here and in defending her decision, not only at the news conference, but she repeated last week that despite the fact that Bernardo has been transferred does not negate the fact that he is a psychopath. As well, last week, my Liberal colleague, Mr. McKinnon, also trying to defend this decision, was quoted as saying in speaking with Ms. Kelly, "I notice a common thread in questions from my Conservative colleagues. There seems to be still an impression that somehow the reclassification of Mr. Bernardo to medium security is some sort of a mitigation of his sentence. Can you tell me, are the pillows softer in medium security?" Mr. Danson, you said this decision sends the wrong message. It sanitizes the full brutality of the crimes, and I fully agree with you. I feel it brings, for my constituents at home and for the families, it brings the administration of our justice system and our correction system into disrepute. And they lead to the question that they simply ask is, who does the justice system serve? And I'm just wondering if you can comment on some of that.
Well, the glib comment about pillows is, if I shared that with the families, that would be gut-wrenching for them. That would be a shock to them to make light of this, with whether the pillows are softer or harder between maximum security and medium security. But it's to suggest that transferring to a medium security does not disconnect us from the fact that Bernardo is a psychopath. To me, that's just words. The fact of the matter is that he will have a lot more freedom and a lot more rights in the medium security. That's why I said earlier that the fact that the perimeter security may be the same between maximum security and medium is irrelevant to me. This is not a discussion as to whether Paul Bernardo is going to escape from a federal penitentiary, but he definitely has more rights. And the justification seems to be that there's more treatment programs when the evidence, even found by the parole board, is that he's not treatable. But I apologize for repeating this, but it does not take into account the sheer brutality of what this man did, and that the punishment side of sentencing principles must prevail in this case. So, that's my short answer to your question.
You also mentioned there must be a separate law. I've put forward a private member's bill, 342, as well. A colleague of mine has actually put forward another one as well, C351, and that would require all court-ordered dangerous offenders and mass murderers be permanently assigned a maximum security classification. It also would repeal the Liberals' least restrictive environment standard for assigning inmates to prisons and restore the language of necessary restrictions. I thought perhaps you could comment on that.
Well, certainly as it relates to dangerous offender indeterminate designation, they should be in maximum security when we're talking about the most dangerous offenders. And as I say, we have to remember that criteria under the criminal code to be designated a dangerous offender is a very, very, very high standard, high criteria, which the Crown has to prove on medical evidence beyond a reasonable doubt. So there's our starting point. So of course, those type of people who when the prosecution can prove that criteria beyond a reasonable doubt should be in maximum security. We still have the parole board. I mean, this is really important, and I know this is really important when you go through the Supreme Court of Canada jurisprudence, even in the more recent Bissonnette decision. There has to be some escape route, in terms of we don't throw away the key forever. So you have to have a process, which is the parole hearing process, in place. But as long as that's in place, the rule should be that these people spend the rest of their lives in maximum security.
Thank you, Mr. Danson. And Chair, if we could, I'd like to seek unanimous consent that we could have another round of questionings.
C'est pas ce qu'on est en train de faire, là.
I felt like we were already in a second round, says Mr. Fortin.
Sorry? We're at third round, Mr. Forte.
Un troisième. Ah bon?
A third, okay. Yeah, okay.
On est au deuxième tour.
I'm up to you. I'm just joining for today, so.
Since we only have an hour, I was hoping we could get unanimous consent for another round of questionings before the voting starts. So a third round.
Third round.
Yeah.
Mr. Julien? You good? Good. Okay, we'll continue on. And thank you, Mr. Benelli, for your questions, and Mr. Danson for your answers. We're moving now to Mr. Biddle, please.
Thank you so much, Mr. Chair. Mr. Danson, first of all, would just like to echo what Mr. Baldinelli said. Your work on behalf of the families. I know I speak for a lot of residents of Niagara when I say thank you for your service to the families and also to the community, which was not to undermine what your clients went through, but community as a whole went through a great deal as well. And so thank you for continuing to act for your clients. It's very important, not only to them, but to our community as well. I know we granted you more time for your opening statement. I think you might have still cut it a bit short. I was wondering if I could lend you some of my time. Were there other points that you wanted to elaborate upon from your opening statement?
Well, there is a point that the families wanted me to make, if time permitted, which is that when we look at the issue that you're dealing with in terms of the transfer, the families, want to emphasize that, solutions and dealing with victims' rights has to be looked at in a broader framework and not piecemeal. And the one point that they did want me to bring to the committee's attention in this respect, the greater picture for understanding victims' rights, is that the families are deeply disturbed by Parliament's failure to reenact Section 745.51 of the Criminal Code following the decision of the Supreme Court of Canada in Bissonnette striking down the section. It is for the families, and I'm sure for most Canadians, outrageous that Paul Bernardo's period of parole ineligibility was not increased by a single nanosecond for the brutal murder of Kristen French. In terms of parole ineligibility, Paul Bernardo got a free pass for the second murder. And that shocked the good consciences of all Canadians, in my view. And it's important to appreciate that the court struck down 745.51 because of the stacking of periods of parole ineligibility in blocks of 25 years. I could draft you a new 745.51 that is constitutionally bulletproof and meets all the concerns of the Supreme Court of Canada. So when we speak in terms of transfers from maximum to medium security, prisons, this needs to be considered in that larger context, larger legal context, dealing with dangerous offenders at large. So that framework should also include amending the CCRA to make parole hearings for offenders like Paul Bernardo every 5 years instead of every 2 years. They just wanted me to make the point that there has to be a greater comprehensive response to the victims' issues.
Thank you so much. And I was wondering if you could, if you have a draft of that potential amendment, if you could send that to the committee.
I haven't. I probably do have a draft somewhere, but I'm happy to do that for the committee and send it to you.
If you have it, if you don't have it, I won't hold you to it. But if it is available, I think, well, I'll speak for myself. I would like to see it, and I think the importance that you're talking about is precision in amending the legislation, and that the offenders that you and your clients, the families are talking about, are very specific and very small in nature versus a broader change to the criminal code. This is perhaps a more broad question, but can you tell the committee how you think victim services in Canada need to be improved?
Well, that's an interesting question. I work with many of the victim services, but they are, in my view, heavily circumscribed by the policy directives within Corrections Canada. But I mean, I think that at least the people that I deal with, I think the good people, they try to assist the victims, but I think that they have their hands tied behind their backs. We get notices of parole hearings and without any regard to what. Let me back. I'll give you an example. With respect to the transfer of Paul Bernardo, they happen to do it at the same time of the anniversary date of Leslie Mahaffey's murder. You would think that in a case of this profile and this importance, they would appreciate that maybe that's not the time to do the transfer. But when we get notices of parole hearings, they'll say, well, you need to have your victim impact statement in within, let's say, 2 weeks or 3 weeks, even though the hearing may be many months away, having no sensitivity or feel that in preparing these victim impact statements, the victims take this very, very seriously. And I think anyone who participates in is at the parole hearings of Paul Bernardo's and certainly other people that I represent, that very serious efforts put into these victim impact statements. So there has to be more sensitivity in terms of the timeline for those to be completed.
Thank you, Mr. Danson. We're going to move on to Mr. Fateh, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Danson, let me start with a clarification. I think I heard you say that your position was that in the cases of psychopaths like Paul Bernardo, they should stay for the entire duration of their sentence in maximum security prisons and not be eligible to parole. But then I think I heard you say later that assessing the security clearance should be done every 5 years rather than every 2 years, or that security aspect. Could you clarify if that is to be assessed every 5 years, that means that it would be possible to transfer someone to medium security institution? Could you just clarify that?
Thank you for the question. I apologize. It must be my failure. I didn't communicate my view clearly. The 5 years that I was referring to was not the reclassification for transfers from one penitentiary to another. The 5 years that I was referring to was for offenders like Paul Bernardo, that their parole hearings, once they hit the 25-year mark and they have a parole hearing, instead of the parole hearing thereafter happening every 2 years for the rest of their lives, it should be 5 years. So I was referring to the continuity of parole hearings, not the transfers. And as with respect to parole, while it's my view, and it was the view of Chief Justice Lesage, that Paul Bernardo spend the rest of his natural life in prison, that is our view. But that's not suggesting that Paul Bernardo is not entitled to appear before the parole board and persuade them of a different view. I think in order for all of us to be constitutionally sound, these offenders, no matter what they've done, must always have the right to go to an independent tribunal like the parole board and try to persuade them to release them But that's why I've been emphasizing that we need much more transparency and recognize, and I think there should be legislative change in this regard, that recognizing that, and it's already recognized by the Canadian Victims Bill of Rights, that these parole hearings are integral to the sentencing and the criminal justice system, and they're public, and everything has to be transparent, and then the system, at least we can evaluate whether or not the system's functioning properly.
Mr. Fate, we're going to move on to Mr. Julian, please, for 2.5 minutes.
Thanks, Mr. Chair. So, Mr. Denson, you've talked about the victims' impact statements, the fact that there isn't enough notice, and that often, in terms of parole applications, victims are asked to prepare what is a gut-wrenching victims' impact statement. Of that, we have no doubt. Sometimes with a few weeks' notice, but potentially not to be used for months in the future. It's a gut-wrenching process because the victims' families believe they're really the bulwark against a criminal psychopath being released into society and creating other victims. So what would be an appropriate time in terms of advising families for victims' impact statements? How long is a process that is reasonable? How can we make the justice system actually respond to the needs of victims?
Well, I think that it should be recognized that they should have a good number of months to prepare, not weeks. And not to receive a form letter that it has to be done in 2 weeks. In fact, we take the time that we need, and they kind of allow it, but it creates huge pressure on the families when they get an official letter from the parole board that they and from corrections that they have a limited period of time. So I think they need a number of months. The other thing that needs to be recognized, and I've seen this a lot, especially Bernardo's now coming up for his third parole hearing. I have other offenders who've had 5, 6, 7. And the only constant in the parole process are the victims themselves, because we have a different composition of the parole board with each different hearing. And it's the families who are able to identify how the offender, more than anybody else, is manipulating the system and saying one thing to one parole board panel and something to another parole board panel, and they don't know. And that's why in our application before which is, they say is before the Supreme Court of Canada, we want public disclosure of the audio recordings of previous parole hearings and the evidence and the testimony of the offender, so that the victim impact statements can be very, very informative and helpful in assisting the parole board in effectively adjudicating the issues before them.
Julian, that's your time. Can we move now to Ms. Thomas, please, for 5?
Thank you very much. Mr. Denton, thank you for your time today and having the opportunity, or taking this opportunity, to speak on behalf of the families. We very much appreciate that. My first question for you has to do with regard to the classification system and the reclassification of an inmate. Right now, the language that is used to determine that is an inmate is supposed to be in the, quote, least restrictive area, or the least restrictive measures are supposed to be applied. But the former language was most appropriate. And so I'm wondering if you can explain for us the difference in this use of language and what you would advise is needed.
Well, I prefer the former language, and to be clear and to be consistent, I don't have a problem with least restrictive as it relates to the majority of offenders with fixed sentences. So I know I'm repeating myself on that, but you cannot apply that criteria to Canada's most dangerous offenders. It has to be an entirely different criteria that has as its number one principle, which is punishment. And that's why I'm saying that, at least in the case of Paul Bernardo, we actually have 2 parole board findings about how dangerous he remains. And that, I mean, transferring someone who doesn't illustrate one iota of remorse or empathy or insight. So when you talk about least restrictive, what does that mean in a practical sense to these particular type of offenders? Why should someone who commits an offense, which, as I say, and thank God the videotapes are destroyed, if you just saw the cruelty, the sadistic brutality of these offenses, the horror. 30 years later, it still gets me emotionally. And to think that we're talking about the least restrictive punishment for this person, that has any reality. I mean, this is what Canadians will not tolerate. And that's what, but they will tolerate all kinds of progressive remedies and rehabilitation and programs for the majority, but not for people like this. So least restrictive is dangerous because it sanitizes the brutality of what's happened in cases like this.
Yeah. Thank you. Thank you for responding to that. One of the other comments that you made in your opening remarks, you asked the question, how can we allow something that is shocking and incomprehensible remain the law of this great country? And of course, in asking that question, you're referencing something that was said by the former public safety minister when he found out, or supposedly found out, that Mr. Bernardo was being transferred. He said that it was shocking and it was incomprehensible. Now, we later found out that actually that was misleading because he had known since March. He had known for quite some time before the transfer actually took place in June. But nevertheless, you make this statement that if it is in fact shocking and incomprehensible, then why would we allow that law to stay on the books? Mr. Denton, if you had to propose one change, the one that we should start with in order to make our system more robust and in favor of victims, what might that be?
That would be to establish legislatively a different criteria and regime for the Paul Bernardos of the world. That's where you start, and I'd be more than happy to help with particulars of that. But that's where it has to start. We've got to stop treating all offenders the same, using same criterias, and as I say, least restrictive. So at least restrictive for someone who commits a white collar crime, a nonviolent crime, is the same criteria we use for a sadistic psychopath. I mean, it just defies common sense. We have to have a separate regime for these individuals, obviously having due regard to constitutional criteria, but it must be the starting point for bringing some sense to this process.
Thank you. And in your expert opinion, do you believe that it's possible to make that differentiation in the law?
Oh, easy.
That's fine.
Easy.
Thank you very much.
Thank you, and thank you, Ms. Thomas. Now we're moving on to Mr. Gahir, please.
Great. Thank you, Chair. And Mr. Danson, I echo the comments that have been made by the committee so far in thanking you for your participation before the committee. We received correspondence to the committee on October 5th from St. Catharines City Council that called on the federal government to review the guidelines for transferring dangerous offenders who show no remorse or empathy for their crimes to medium security prisons. In your capacity as a lawyer, would you agree with this request, and why?
No, I would agree, because the current system is broken and it's not responsive to the gravity of the offense, and that's why I've said repeatedly we need to bring in an entirely different regime for these particular offenders.
And how would that regime be different? Could you go into detail regarding that?
You're talking about the difference in the regime for the purposes of transferring from max to medium?
Specifically for the individuals who show no visible signs of remorse or empathy for the crimes that they've committed.
Oh, my view on that is that if the evidence is, as in this case found by the parole board, that the offender has no remorse and no insight, that he cannot be even considered for a transfer out of maximum security. I mean, it's just absurd to think that they somehow get a benefit by, after, in this case, 30 years in prison, having no insight. I'm telling you, I mean, again, I don't mean to repeat myself, and it's why we have this leave application before the Supreme Court of Canada. The entire country should listen to the public audio recording of Paul Bernardo's evidence at both parole hearings. He talks about what he did to my clients, like all of us would talk about the weather. When he's asked by the parole board, why did you have to inflict such pain? And he says, well, they weren't doing what I asked them to do. So, what did you expect me to do? This is the evidence. We're transferring this guy to medium security. That's what I'm talking about. They're sanitizing the brutality of what he did. And so no remorse, no insight, no empathy, nothing, which is the hallmark of psychopathy. You don't get transferred into medium security. You don't get a favor. You don't get a benefit. You don't get the extra freedom that you get in medium security.
Yeah, thank you. We know this is obviously a very difficult topic, so we thank your testimony. Thank you for your testimony. So I think you've indicated to the committee that more information, including parole hearing records, should be shared with victims so they can prepare proper and maybe more meaningful victim impact statements. These files could, however, include psychiatric assessments and disciplinary records. So could you explain for the committee why you think this information is needed for victims to share their concerns?
Well, thank you for that question. That's an important question from our perspective, because we're met all the time with, under the Privacy Act, that this is very, very personal information. We can't share with you, the psychiatric and psychological reports that have been generated with respect to a particular offender. Let's remember what the Privacy Act says is that when you have to weigh, if it is personal information and it is private, you have to weigh the public interest against the privacy interests of the particular offender. So let's understand that legally. Everyone throws up privacy rights, and they just ignore the law that requires there to be this evaluation, this proportionality between public interest to know and the offender's right to privacy. But those very reports that you refer to, they are discussed openly at the parole hearings. So where's the privacy interest? You just need to read, and I urge the committee to read both parole board decisions as they relate to Paul Bernardo, and look at the incredible amounts of personal information, as it should, that is in their decision, which is a matter of public record. It's like closing the barn door after the horse is bolted. This is not personal, private information. This is part of the criminal justice system. This is part of a public parole hearing. This is asking for a public remedy. So this notion that, of course, we should have access to the information, other than the parole, just trust the parole board. In this case, they've done a good job with Bernardo on the last two hearings, but the principle is transparency. And the public has a right to see this evidence, just like they did at the trial, at his dangerous offender application. So this notion that because it's psychological records, psychiatric records, things of that nature, he's asking, and other offenders similarly situated, he's relying on that very evidence to persuade the parole board, let me out of jail. Let me go back and integrate with the public. And the public doesn't have a right to know that evidence.
Thank you, Mr. Danson. We're going to move on to Mr. Baldinelli, please, for 5 minutes.
Thank you, Chair. And again, thank you, Mr. Danson. In earlier testimony, when you were speaking with my colleague, Ms. Thomas, excuse me, you were talking about legislation and changes that we could meet, and you talked about different criteria, a regime that is needed for the Paul Bernardos of the world, and that all inmates cannot be treated the same. And when she asked, would it be difficult to make that change, you indicated right away, you said it would be be easy to make that type of change. So I was wondering if you could follow up. Do you have recommendations that you could share with us, to share with this committee on things that we could do to make some changes to improve our system?
Well, I'm happy to post this, submit some further submissions to answer that. But I think, I would start with, defining the Paul Bernardos of the world, these sexual psychopaths, and define what that is and what and the criteria that makes up a diagnosis of psychopathy. And then there's psychopathy, and then there's sexual sadistic psychopathy. Define it. And so you start there and you separate them from all other offenders. And that's why I said earlier, if the Canadian public knew that these people are taken care of and they're safe from them and there's a rational criteria and system, they'll open up their arms for rehabilitation and treatment for all other kinds of offenders. So I mean, in the limited time, I can't do much more than that, but I think that you start off by defining this criteria and separating it, and then the recommendations flow from that.
If you could, perhaps you could submit something in writing to the committee to provide something more fulsome with regards to that. And then, again, thank you for that. Also, I just want to follow up. In our previous committee hearing, we had Benjamin Roebuck, the victim's ombudsman, and he mentions about the system that strikes the wrong balance between victims' rights and prisoners' privacy rights. And I was wondering, we had discussed the system, like, for example, the transfer, and whether or not, the victims' families had any input or could provide statements for consideration so that they're considered prior to a transfer ever being made. And I wonder if you have some thoughts on that.
Well, I agree with him, and I think that would be helpful because in this case, of course, there was absolutely no input. We weren't even asked. It was just a fait accompli. But again, I think that this whole notion of the transfer is that the problem I have is more fundamental, which is there really does have to be what I've characterized as a very different regime for these kinds of offenders, and because they're a minority of the federal inmate population. I don't think these should be administrative decisions. These may be something that the parole board can consider and give direction if certain criteria are met. But you have to know that the criteria that they're using right now is defective because, and I've talked to the commissioner as well, and I've expressed this, but how can you justify a transfer, as I've said repeatedly, when the parole board itself is determined based on all of the evidence that the offender is beyond treatment at this stage, has no remorse, no empathy, no insight. They applied a criteria that they say they followed properly that still nevertheless justified this transfer. Plus, I would repeat the earlier comments that I've made about the particular offense this person committed. That's why it's shocking and incomprehensible. That's how Canadians responded. Instinctively, it was shocking and incomprehensible. So clearly, and this is so hard for the families, and I think everybody on the committee, and I always try for the last 43 years on these issues to be nonpartisan because I think it is nonpartisan. We're protecting people from dangerous offenders. That we can allow something that the minister and the prime minister and other political leaders called shocking and incomprehensible, and then leave it. Like, what do I, as their counsel, what do I tell them? What's the answer to that question? There is no answer. I take all the political leaders at face value as being genuine and sincere when they talk about this being shocking and incomprehensible. And then we turn around and say, well, what are we going to do about it? Well, hopefully your committee will do something about it because it has to be changed.
That's a good point.
This is the type of stuff.
Mr. Danson, that's a good point to end on. Thank you so much. Mr. Fateh, please, for 2.5 minutes.
Sorry,
It's okay.
je croyais qu'on était rendu au conservatoire.
I thought it was the Conservatives' turn, but sorry. 2.5 minutes, sir. Chair?
Alors, et Monsieur
Mr. Danson, I only have 2.5 minutes.
I admit to that mistake. It's actually the Liberal Party's turn.
well, I don't mind if you give me 5 minutes. That's okay.
And I'm going to go to Mr. Scheifke.
Okay.
Correct?
Thank you very much,
We're
Mr.
on
Chair.
Thank you. Excuse me, Mr.
Mr. Danson, I want to begin by thanking you for your steadfast work in representing the families who unfortunately fell victim to the brutality of Mr. Bernardo. Your testimony is very valuable to the work we're doing here, and we very much appreciate your time today, particularly with your 40 years experience and the work that you've done with the families. In solutions mode, looking forward, trying to do things better. My questions are, how could victims' rights be better considered in the offender's reclassification process? I had mentioned in last week's testimony that I was taken aback to learn that the victims and the families were only informed the morning of the transfer. What could have been done better? What needs to be done better? And particularly in detail, what are you recommending to this committee that the government do moving forward with regards to that?
Well, first of all, I would strongly recommend that the victims be notified well in advance, so they're not shocked or reading about it in the paper for the media. So that's important, that they're not blindsided by such a decision.
And just sorry to cut you off, Mr. Danson, when you mean way in advance, I'm looking for detailed response here because I don't want any misinterpretation, right? Way in advance could be a day, could be 2 days, depending on the person who's reading it. What would your suggestion be? Would it be a week? Would it be 2 weeks? Would it be a month?
Yeah, fair enough. I would think that I was about to make this point too, and I'm going to answer your question directly. That when we talk about transfers, as I say, there's always a continuum of seriousness, and so I'm just focusing on like the serious offenders who have life sentences, not fixed sentences, because there just has to be a different criteria. Otherwise, it's not going to be workable. Even for Corrections Canada. But for the people who have life sentences and indeterminate sentences, I think that they should be have advance notice by a number of weeks. Certainly anywhere between 3 to 4 weeks is my view. But again, and I apologize for repeating myself, but there has to still be this different legislative regime dealing with these kinds of people before you even get to whether or not a transfer is appropriate.
Thank you. When you're talking about an overall regime, let's talk a bit about Bill C-320. In your opinion, what does it do that's good? And in your opinion, what needs to be done above and beyond what is being proposed?
Well, I have to say that I'm not familiar with the numbers. I know everything is a bill with a number.
Sorry, it's the disclosure of information to victims that is being proposed.
To answer that, I don't feel qualified to answer that question today because I'd have to, study it and read it, and it would be unfair of me and inappropriate to comment on something that I'm not properly informed.
So I guess I'll pose it this way, Mr. Danson. How can Correctional Services Canada be more transparent with survivors and victims' families and friends?
Well, I think when they get an Access to Information Act request, like they have from many of my clients, they should fairly and properly comply, and not use as an excuse and a pretext the privacy rights, so-called, of the offender in information that the offender themselves is relying upon at a public hearing to be relieved from the full consequences of their sentence. I mean, it literally is that simple. It starts there. There has to be transparency. When we do our ATIP applications, Access to Information Act, you know what I get from Corrections Canada and the Parole Board? they send back to me the victim impact statements that we prepared. They literally send back information that we've provided to Corrections Canada and the Parole Board. They give us nothing with respect to facts relating to issues that are relevant to public safety, which is the statutory mandate of Corrections Canada and the Parole Board.
Thank you, Mr. Danson. I had one last question, if the chair will permit, and this is, I want to give you an opportunity to share with us perhaps something else that the families had shared with you and asked you to share with us that you think would be helpful in making the necessary changes moving forward.
I'm sorry.
Is there anything else you'd like to share with the committee, sir, that has been shared with you by the families that you think would be helpful?
I think I've covered it off. That the different regime treating them differently. I'd just be repeating myself. So I think I've given you their main concerns, and also the huge concern with respect to transparency is of vital importance to the family.
Thank you once again, Mr. Danson. Thank you, Mr. Chair.
Thank you, Mr. Danson. And now we'll move to Mr. Fateh, please.
5 minutes.
I'll be generous, Mr. Fateh.
Yeah, merci, Monsieur le Président.
Thank you, Mr. Chair. No, seriously, I have 5 minutes, actually.
Okay.
Okay. All right, Mr. Danson, in 2 minutes. Currently, victims of an offender serving a sentence of over 2 years have to register to receive information on this offender. So they have to register with Correctional Services Canada. They have to register with the Parole Board. I'd like to hear your view on this. Does that actually work, this way of proceeding, or would it not be better to just automatically provide victims and their families some information? And a second aspect of the same question, what are the limits to the information we should provide? At this point, we're talking about protecting the confidentiality of some of the offender's information, but we also want to adequately advise the victims. Is the obligation to register a good way to proceed? And what's the limit of the information that we should provide, transfer to the victims and their families?
Well, I suspect that there has to be some system of registration because the numbers could be significant, and some victims want to stay totally involved and others don't. So I don't have a problem with the registering. I must say I prefer the easier for the victims that automatically they're informed. But I've not had any of my clients object to to registering. That way you have proper addresses, phone numbers, and they do communicate. I mean, they let us know when when there's as I say, when the parole hearings are coming up, whether there's been an escorted temporary absence, things of that nature. But the information is as I say, is very, very limited. But when it comes to matters that count, such as the parole hearings themselves, I mean, there's certain situations where the parole board does paper reviews instead of full parole hearings, and that's a real problem for the families. And that's a whole other issue that I think needs to be addressed. But in terms of the registration itself, we don't have a problem with that. At least it's gives them the current contact information.
Et la nature des informations qui peuvent être transmises.
And the nature of the information that can be shared. Do you have any comments on that? Protecting the confidentiality of the privacy or the information for the offenders versus the rights of victims?
Well, I come back to a central theme of what we've been sharing with you today. Is that the moment...
Mr. Fateh, I was generous, believe me. Thank you, Mr. Danson. Hopefully someone else will pick that up. Can we go to Mr. Julian, please?
Thanks, Mr. Danson. You talked in your earlier answer to my question about the impact on victims, the amount of time that they get notice for preparing new victim impact statements. You implied that there's a form letter that goes out, which is unbelievable to me when you think of what those families have been through. So to what extent do we need to overhaul correctional services so that they're trauma-informed, and the parole board so that they're trauma-informed? And what kind of supports has the French and Mahaffey family received from the federal government as they've been going through this? Have they received supports for psychological support, for mental health support? To what extent are we providing supports to victims who are going through and reliving this trauma?
Well, there's in terms of the French and Mahaffeys, there's no support other than there is a victim's a person in victim services with corrections and with the parole board that is there to provide information. But other than that, they're on their own, and in their particular case, I've been working with them over the past 30 years, and now taking very seriously preparing these victim impact statements. And it's through that process. I mean, I have to tell you, one of the most gut-wrenching things for the families is that when they're sitting in a parole hearing and they hear the testimony of the offender and the questions that are asked of the parole board, and then 2 years later they're before a different panel, and then they see how the system's being manipulated and no one is catching it. That's really, really tough for the families. Talk about victim impact. That has huge impact, and that takes me back to my transparency point and the access to information request, so that the important evidence is presented and the manipulation and contradictions are identified, and the parole board can use it as it will. But often, if it's not for the victims, they won't even know that these inconsistencies exist.
Would it help their family? These families, would it help the French and Mahaffey families if they were provided supports, even now, having relived this trauma numerous times? Would that make a difference if supports are provided?
I think at this stage, it's a good question, and it's something I haven't recently talked to the families about. But I think at this stage, they would much prefer to just be left alone and never hear the name Paul Bernardo or Carla Homolka. But they recognize that when these parole hearings come up, they have to be there.
Thank you, and good question, Mr. Julian. Now we're moving on to Mr. Motz, please.
Thank you very much, Chair. Mr. Danson, thank you for being here, and as others have said, thank you for your continued advocacy for the families of these horrific crimes. A couple of questions. You had indicated in your opening remarks that something needs to change. There needs to be some change. There's the shock of this to society, to the Canadian public. Can you make any suggestions? Many people in my riding and across the country have suggested that the government has full right and authority to insert themselves in this. The minister can revoke this particular transfer. Is that something that the families would find to be of value to them, given your comments today?
Yeah, absolutely. I mean, I respect, and the families respect, that to a very large extent, the independence of Corrections Canada and the parole board. Parole board being different because it's a quasi-judicial tribunal, although some people would quarrel with that language. But when we come back to what we said earlier, that the Prime Minister and the Minister and others are talking about shocking and incomprehensible decisions, and then say there's nothing we can do about that. I don't buy that. The buck stops, with the government. It stops with the Minister. It stops with the Prime Minister. I mean, they're the ones who are answerable to the public, and if they see something that is rotten or something that is shocking and incomprehensible, absolutely, it would be the exception to the rule. But yes, they do need to insert themselves and take a leadership role and correct this.
I appreciate those comments. Also in line with the frequency of parole hearings, Mr. Danson, you've indicated the impact that this has negatively on families who deal with this. I know that from my own past experience in law enforcement. the frequency with which the current system handles parole hearings for designated dangerous offenders, is it something that you think the frequency should be extended so that it's not as every 2 years, it could be 5 or greater, especially for someone in this circumstance who has shown the incapacity to even be changed?
Absolutely. For these types of offenders, and as I said earlier, you have no idea how quickly 2 years goes. By the emotional trauma that the families go through to prepare their victim impact statements, to then attend at the hearings and give their victim impact statements, and then all of a sudden, within a year and a half, they're getting notice of the next parole hearing, which on average is every 2 years. It's without any change in circumstances for the offender. So, in my view, they're entitled to their parole hearing, and we're talking about these offenders like Paul Bernardo, not the majority. That it shouldn't be every 2 years. I've recommended anywhere between 5 and 7 years, and even at 7 years, I would propose in terms of any legislative amendments. Would be that if the offender or their case management team within Corrections Canada, that there's been a breakthrough medically or there's been a significant change in circumstances, that the offender can apply to the parole board to have an earlier hearing so that you have all the constitutional protections in place, the due process protections in place. But I think it should be, I do believe it should be 7 years for someone like Bernardo after their first hearing, but they have to have the opportunity to apply to the parole board to move that up if there's a change in circumstances. But in this case, and we've had 2 parole hearings for Bernardo, and there's been no change in circumstances. So why put the families through this every 2 years?
Thank you. I couldn't agree with you more. Mr. Danson, Public Safety Canada, Correctional Services Canada claimed that the Privacy Act placed significant limits on their capacity to share offender information. The former Minister of Public Safety repeated that excuse in the media. However, the Privacy Commissioner has directly rebuked that claim, noting that the Commissioner of Corrections can share information in exceptional circumstances. Can you discuss your opinion with respect to how personal information of the dangerous offenders that is normally protected under the Privacy Act should be handled to prioritize victims' rights over offenders' rights in these exceptional circumstances?
Right. Thank you. First of all, I reject that we require exceptional circumstances. That's not the law. That's not what the statute says. And I think that's important because Corrections Canada and the Parole Board is always looking for these exceptional circumstances. And the way they define exceptional circumstances would mean that there are no circumstances in which they would ever make disclosure of personal information of an offender, even though it's the personal information that's going to be disclosed at a public hearing. In the case of DAG, the Supreme Court of Canada says that the Access to Information Act and the Privacy Act have to be read in harmony. The purpose, and I just have it in front of me, the purpose of the Access to Information Act is the purpose of this act is to enhance the accountability and transparency of federal institutions in order to promote an open and democratic society and enable public debate on the conduct of those institutions. That's the legislative purpose. Then Section 19 of the Act takes you to the Privacy Act, and it's the Privacy Act that then says, and the exact language is that they can disclose the information if the head of the institution feels that the public interest in disclosure clearly outweighs any invasion of privacy that could result from the disclosure. So it's clear
Should end
that
there.
if
Thank you, Mr. Danson. Appreciate that. Now we're going to move on to the final question here. Ms. O'Connell.
Thank you, Mr. Chair. Thank you again for Mr. Danson for staying longer than scheduled. It has been helpful testimony. The last Mr. Mott spoke about the minister being able to issue an order and revoke the transfer. However, we heard testimony at this committee that there is no such legal mechanism to do so. And although it may feel right, because certainly the public and certainly your clients, friends, and families want to see that happen, but it would actually cause even more upheaval to do something in the public realm that could not withstand a court challenge and would have Paul Bernardo in the news even more and having more court cases. So I just think it should be clarified that it was clearly said in this committee that an order from the minister on an individual offender's classification or transfer would not be a legal order that CSC would be able to accept and would certainly not withstand a challenge. So I just think that should be clarified. When we're talking about notification to victims' families, and in particular around transfers, we heard testimony, and I certainly agree, the issue around families finding out in the news or the day of is completely unacceptable. I think there could be challenges around the physical transfer taking place and wanting to ensure that nobody interferes in the physical transfer. So there has to be a better balance, though. Do you think there would be an opportunity to, for example, say a transfer is imminent or something is going to happen, but without maybe the specific dates and times or location? Would that be a better mechanism to give, for example, your clients and the friends of the victims were very clear that they needed time to process this as well? Could there be a better balance in terms of making sure that the operational standard is upheld, but also give time for families and victims and their friends time to process what might be occurring?
From my client's perspective, they don't. The issue is not the actual date of the transfer. It was the shock of finding out after the fact. So I think as long as there is appropriate consultation prior to, and they have the ability to absorb it and say what they need to say, they don't need to know the actual date. I don't accept. I've heard the argument before that they may be concerned about someone trying to interfere with the actual transfer. To me that's pretty a bit rich. They can handle these transfers without worrying about people trying to stop it. But having said that, the issue is not knowing the exact date and time or mechanism of the transfer, but rather having advance notice.
Thank you. And certainly I understand in this case that the date and time may not be an issue, but I could see in the case of, for example, organized crime, you'd certainly want to make sure that there's some protections around who knows what and when, but there would be victims included as well. And so there has to be a better mechanism and process, but while making sure, for example, again, this case may not be the example, but as we've seen in corrections, sometimes these processes affect a variety of cases, a variety of offenders, a variety of risks. So I'm appreciative of your perspective on that. I'm just looking at how much. Okay, thank you. And in terms of the notification, we heard testimony from the victims' friends as well that they need additional supports in terms of how to even communicate their feelings prior to a decision being made. Do you have any experience in this realm, perhaps with clients, in terms of helping them prepare statements, if they even know a statement is needed, but also allowing them to access services? I think my colleague, Mr. Julian, brought it up as well, the need for even counseling to be able to process something that might be occurring or a change in an offender's status. Is this something you've ever heard of or come across or think it could be helpful?
I have heard of it, and I think it would be very helpful. I was directing my comments to the Frenches and the Mahafis, where I spent significant amounts of time and work with them. But obviously, there's lots of victims who don't have counsel at all, and I think it's very important that they have access to resources to help them emotionally. And I think that's obviously the role, in my view, of victim services, and it should be properly funded.
Thank you.
And Mr. Danson, that concludes our questioning for you today. And I just want to say thank you for your input on a very emotional issue for everybody, and we're certainly glad that we finally were able to have you here. So with that, I'd thank you, and hopefully we have you back again sometime, maybe on a better issue. Thank you.
Great. Thank you very much. Thank you.
Committee, I just want to, the clerk has circulated earlier today the committee budget. Committee has completed its fourth meeting on the study of the rights and victims declassification and transfer of federal offenders. A project budget for this study in the amount of $3,000 was distributed by the clerk earlier today. Do I have the agreement to adopt the following motion? That the proposed budget in the amount of $3,000 for the study of rights of victims, declassification, and transfer of federal offenders be adopted. Moved. And good? Okay. Is the committee in agreement to adjourn the meeting? Yes. Meeting adjourned. Thank you.